My name is Sarah Whittington, staff attorney with the Justice and Accountability Center. This video is meant to give an update on the current expungement law as of August 1st, 2020, and also provide some background information on our processes and the procedures the courts are facing after the COVID-19 pandemic. We know that courts are reopening and clerks are allowing for filings. If, however, you had a court hearing that was scheduled when the courts were closed due to the COVID-19 pandemic, you must contact that court to find out when your court date has been rescheduled or if your expungement has already been granted. This video is meant for informational purposes only, and we encourage you to use this video and the how-to guides available on our website to determine if you might be eligible and to know how to collect paperwork for any potential upcoming events. JAC is currently not planning for any in-person clinics at this time until it is safe to have a large gathering with close proximity inside. We are working to plan how we might be able to provide expungement services through virtual means, so please check back later in October to see if we have a remote event planned. Any remote event would require an email address and the scanning of all of your court records, which we talk about later on in this video. An expungement is the sealing of your record from public view. A criminal record exists when a cop puts pen to paper on you, either with a summons or arrests you. That record will exist and is available for public view or purchase on a background check until you complete the expungement process. An expungement does not destroy your records, and some agencies will always be able to see your records. Law enforcement, state licensing agencies, and employment with minors like schools or daycares are some examples of who will always be able to see an expunged record. The example that we most often use is that the Nursing Licensure Board will be able to see an expunged record and determine your licensure eligibility, but the hospital or the company that you're applying for, that you're seeking to work at, will not be able to see your expungement or expunged records. When we discuss collecting your paperwork, in Orleans Parish, the court is currently closed until at least phase 3 to the public. So we encourage you to call closed records at 504-658-9090, and you'll ask for an expungement packet. The person in the office might collect some information and they need a good working phone number, because once your records are ready, they will call you to come pick them up from the court. In all other courts that have access to the clerk's office right now, you'll go to ask for your bill of information and your sentencing minutes or your disposition. There's often a cost associated with these records per page. The forms for an expungement are standardized across the state and are available on the Justice and Accountability Center's website or from the clerk's website, and oftentimes available at the clerk's office in the court. You do not need an attorney to file these forms. Most frequently, we get the question of when am I eligible for an expungement, and we'll be talking about cleansing periods. It's important to note that your cleansing period begins when you come off of paper, when your probation ends, your parole ends, or your sentence ends. And it is possible that you have a probation terminating early, or you can have probation extended, but the date that you come off of paper is going to be the date that we need to know. Currently, there are certain allowable expungements without any waiting periods whatsoever. From whenever the case is closed or the case dismissed, you can immediately file for an expungement of arrests that did not result in conviction. The DA would have to file a certification letter that acknowledges that the charges are dismissed and they may not be brought back. Additionally, a first offender pardon or an 893 for felonies or 894 for misdemeanor deferred sentence with a set-aside is also eligible for an immediate expungement once the case is closed. First offender pardons require that all court costs are paid, and a deferred sentence requires satisfactorily completing your probation. You cannot have an unsatisfactory probation termination and receive your set-aside. As of August 1st, there are no longer any waiting periods between expungements. The law used to make you wait 5, 10, or 15 years between eligible expungements, but now you are eligible to file as many as you are eligible for and can pay for at one time. There are still restrictions that allow only one 894 set-aside every 5 years, and you only can receive 2 893 for felony set-asides in your lifetime. For misdemeanors, you must currently wait 5 years with no felony convictions if you do not have an 894 deferred sentence. That 5-year cleansing period without felonies starts from when you come off paper. There are also, however, several misdemeanor convictions that are never eligible for an expungement. Those include if you were arrested for a felony sex offense and pled to a misdemeanor, you're only eligible for an interim expungement. If you were convicted of misdemeanor domestic abuse battery or stalking, those are also ineligible for a expungement ever. Felonies right now have a 10-year cleansing period with no convictions whatsoever. If you receive a new misdemeanor or felony conviction, it restarts your cleansing clock, and you would need to then wait 10 years until you are eligible, unless there is a first offender pardon or an 893 set-aside deferred sentence. There are more ineligible offenses for felonies. The biggest group is called crimes of violence that are defined under the law. If you have a conviction for a crime of violence, it is not ever eligible for an expungement, with a few exceptions. Aggravated battery, second-degree battery, aggravated criminal damage to property, simple robbery, purse snatching, and illegal use of weapons can be eligible after 10 years. The law used to require 10 consecutive years of work employment, but that was removed this year as well. So as of August 1st, 2020, you just have a 10-year cleansing period like other felonies. However, other felonies that are never eligible for expungements include sex offenses that require registration, the distribution of drugs, and domestic abuse battery. Possession with intent to distribute is eligible for an expungement, so you want to check your paperwork very carefully for what your conviction was. We mentioned earlier first offender pardons. Those are automatic letters generated through probation and parole when a person completes their sentence and pays all of their court fines and fees on their very first felony conviction. These letters restore your citizenship rights to vote, to work, and potentially to hold office in certain cases. However, it does not restore firearm rights, and a first offender pardon is not the same as an expungement. It does not remove any of your records from public view. If you're not sure if you received a first offender pardon letter or are eligible, you need to contact your probation and parole office to see if they have one on file for you and arrange to pick it up, because you would need that to file your expungement. Currently, the costs for an expungement can be very prohibitive. There is the eligibility for a fee waiver at the discretion of the DA, which waives all fees for everyone. However, it's only if you have no conviction or diversion on the charge you're seeking to expunge, and no pending charges and no convictions ever on your record. Without meeting all of those criteria, the cost for an expungement is $550. For DUIs, it's $600 or $650, depending on the OMV fees that you would have to pay. That cost is broken down with $250 going to the Louisiana State Police, $200 to the clerk of court, $50 to the parish sheriff, and $50 to the district attorney. You need to contact your local court to see how they accept payment, but many of them ask for 4 separate money orders to each agency. Once you know you're eligible and are prepared to pay for your expungement, the timeline is that this process will take several months. If you require a motion to set aside because of your 893 or 894 sentence, it is a 30-day window between when you file and when you may have the court schedule a contradictory hearing. You must have a hearing for a motion to set aside, and when it is granted, you are then eligible to file your expungement. The motion to set aside does not have a cost and can be filed for free. Your motion to expunge has a 60-day waiting period between when you file and when you may have that expungement granted. That's because the clerk's office will serve all the other agencies listed in the expungement motion and allow them to potentially have an objection. If the district attorney, the arresting agency, or the Louisiana State Police object to your expungement, it may require a contradictory hearing. If no one objects, the court may just sign or grant your expungement. However, many courts do set a court hearing so that it is granted on the record. But that hearing should happen at least 60 days after you file. Once your expungement is granted, congratulations, you need to make sure that you get a certified copy of your expungement stamped and sealed from the clerk of court's office. Once you have that, please store it in a fireproof, waterproof place, and also keep copies in your email or in the cloud or on your phone in as many places as possible, because once these records are sealed, it is extremely difficult or impossible for the clerk to then hand these records back over to you for any reason. All individuals listed in the expungement motion must remove your record from public view. The Louisiana State Police will send you a certificate of compliance, usually in 2 to 3 months after your expungement is granted, that acknowledges that they have removed your records from public view. Once you receive that, it might be in your best interest to search again and see, is anything still available and can anything be seen? If it is, unfortunately, it is up to you to dispute all of those incorrect records with each background check company or court that needs to remove those records. Expungements and pardons are different. The final piece that we would like to make is that an expungement removes your record from public view, but there is a level of pardon that can either restore your firearm rights or an executive or gold seal pardon that actually operates as clemency. That returns you to a status before your conviction, restores all of your rights, and forgives the crime as if you were found not guilty or not convicted. It does require an application, advertisement, and hearing to the Board of Pardons and Parole, but it is completely at the discretion of the board, and there is no timetable for those to be granted. I hope that this information has been helpful to you and that you might be able to use it in the near future. Again, if you can collect your records and be ready to check back for any virtual events, we look forward to meeting with you individually and discussing your specific record in the future at one of our clinics.